Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy by TrustArc. Please welcome our hosts, Paul Breitbarth and Kay Royal.
2020 is the gift that keeps on giving. Today we revisit some of the issues we have discussed before, but with a guest with a unique global perspective. Our guest today is an American in Brussels. He is the Deputy Chief Privacy Officer of US-based pharmaceutical Merck. Chris Foreman has practiced law in London, Washington, D.C., Istanbul, New York, and Moscow, and as said is currently based in Brussels. Merck, or MSD as it is often known, has been an active player in the international corporate privacy community and a big advocate for interoperability and company-wide compliance programs. They are one of the few having both EU-binding corporate rules and APEC cross-border privacy rules, trying to ensure the best possible safeguards for international data transfers. We'll talk to Chris about his views on international transfers and how they are impacted by the Schrems II decision. To what extent can accountability be part of the solution to the current challenges? That and much more in today's Serious Privacy. My name is Paul Breitbarth.
And I'm Kay Royal, and welcome to Serious Privacy. I am absolutely delighted that we have Chris on the show today. Paul gave a wonderful introduction because Chris is friends with our general counsel, Hillary. And so I really love the idea of having you on here. Maybe we can get some secrets on Hillary, maybe?
Attorney-client privilege.
Love it.
Hillary is a fabulous person, and we worked together for many years to set up the privacy organization within MSD Merck more than 2 decades ago. So when I was offered the opportunity to join the show, I jumped at it. I couldn't say no.
And we love it. We absolutely love it. So, okay. The unexpected question today, and for our listeners, as I just disclosed to Chris, it really is unexpected. I don't have the question until I get here. I pick a question while Paul's talking. I typically take my questions from this book, Q&A a Day, 365 questions, 5 years, 1,825 answers.
So we have a few more episodes to go before you run out of questions.
Just a few before I run out of questions. So this one is, if you were a literary character, who would you be?
A literary character. Maybe the cat from Master and Margarita.
Ooh, fascinating. Why?
All the mischief that he undertakes in Moscow. I mean, it's an analogy, obviously, to Stalin, but just the ability. And I got into that book when I was commuting to Moscow back and forth for 2 years, and there was this bar there that actually had all the characters of the book as paintings on the wall. And it was just lovely to see the way that they had set that up back, 30 years ago, and I've always enjoyed it. I hadn't thought of that character for quite a while, and I was reading in Monocle, in their online weekend edition, somebody that there's a Q&A about what do you do every day on a typical weekend, and what's the most interesting book that you've recently read? And they said, Master and Margarita, and it triggered some thoughts in my mind. So I actually pulled it out, and I started looking at it again over the weekend, but it's a great book.
I love it. I have not read that one, but of course I've heard of it. Fascinating. Paul, what about you? What literary character would you be?
Oh, there are so many, but I would probably go for Rémi from Sans Famille from Hector Malot. It's translated in English as Nobody's Boy, I believe, but this is my favorite children's book. I've read it many times in Dutch, but also in French, and It brings back very good memories. And even though the story is often very sad, it's also very beautifully written. So I guess that would be my pick.
Love it. So Paul would probably imagine, and anyone who is listening to the podcast, I think before this one, would probably think I would pick Maleficent, and I think she qualifies as a literary character given it's a Disney story, the Sleeping Beauty. But no, I actually would love to be Eve Dallas in the series by J.D. Robb, because Eve Dallas is a girl that came through huge traumatic abuse as a child and grew into being one of New York's top detectives. Not to mention she's married to probably the richest man in the world. So
That's
But that has nothing to do with it.
that has absolutely nothing to do with it whatsoever. But she's smart and she's sassy, and yeah, that's who I would like to be, Eve Dallas from J.D. Robb. And J.D. Robb is Nora Roberts. I think Nora is more of her pen name than J.D. Robb is. I probably should research what her actual name is. But I absolutely love the series, and I think they're up to 34, 37 books, maybe 40 something, and I read every single one of them like every other year. So, love to read.
We'll put all the links in the show notes.
I will put the links in the show notes. All of us will, to each of our stories, because I think that's awesome. So, okay. On to the questions. I think, Paul, you have one teed up already.
Well, yes, Chris, maybe just start with your general response to the Schrems 2 decision. Is it currently mayhem in your work, or is it business as usual?
Okay, there was no lead up to this one. It was just dive right in. Schrems, let's go, Chris.
Of course.
Well, my answer is probably going to be different from a privacy officer in a non-BCR entity. I think that makes a major distinction. Overall, having the standard contractual clauses reaffirmed as valid was key. I mean, that's really what everybody in the industry was hoping for. The additional, the second shoe that dropped in the sense of the invalidation of the privacy shield wasn't unexpected, but I think most were waiting for that to be in the follow-on case that had been suspended from France, as opposed to being added to this one. Now, the precedent from the earlier case, Schrems 1, when it came to the safe harbor, where, literally within 24 hours of the Advocate General's opinion coming out, that the court just on their own invalidated, in some ways set the precedent for that. But I could definitely see many companies that have only had the standard contractual clauses to utilize to transfer data are really scrambling to work out what are supplemental measures. How do you overcome the issues, particularly for transfers to the United States? And that's going to cause a lot of people grief, and is causing people grief. Pretty quickly after the safe harbor was invalidated, the commission came out and said, oh, you've got a bit of a transition period. And we've been waiting for comparable statements to come from the commission, which have not been forthcoming. But there's been a lot of other activities out there. So it's causing some churn, and a lot of people are still trying to grapple with what precisely it requires. The commentators have had some interesting observations. I don't always agree with all of them, and some of them have not come to light, which is good. But I think that this a self-assessment for every type of transfer to the country is one that's going to overwhelm a lot of companies. But I also think people may be focusing improperly on the wrong countries. The US gets a lot of attention because that was the center of the case. And there are unique aspects to 702 and the executive order and how we deal with those. But, people immediately started talking about, oh, well, then, data localization laws in Russia and China will not be able to send anything there. It's like, well, wait a minute. Data localization laws are requiring local data to be stored locally and only a copy to be exported. Now, we know that it's basically done for surveillance purposes by the security authorities and not necessarily because of data protection requirements and concerns about their citizens or residents. But if you have EU data that needs to be processed, it's probably not that likely that you're going to be shipping it to either of those two countries for processing. So I'm not as concerned about transparency issues and things to be dealt with for those markets. But for the US one, that's a major data exchange that occurs. And you have to start looking into some of those steps on what you can do, what will protect your data more when it's in transit to the US. And that's one of the pieces of legislation. And then what do you do once it's at rest in the United States? And what can you as an importer do to protect that? So there's a lot there, but I'm sure we'll flesh out all these different topics as we have further questions.
Yeah, I think it's really fascinating. And one of the things that surprises people, and you touched on it, is the U.S. is not the only country you need to worry about sending data to. I mean, there are other countries who have known mass government surveillance. And some of these are Australia, Canada, China, India, Israel, New Zealand, Switzerland, the United Kingdom.
I was just about to say the UK, and that everybody thinks that they're going to get an immediate adequacy decision, and they're not. I mean, the Australians really struggled for 10 years, or 10 years ago, they struggled extensively to get the adequacy decision, and it failed precisely because of the surveillance issue. And that's why they're not even pursuing it anymore.
Yeah, so a lot of people don't think about that. This is not strictly a U.S. decision.
No.
And when you say that companies are struggling to figure out what to do, let's be honest, most of the companies I work with that use standard contractual clauses, and I will call out absolutely zero names whatsoever, don't even read them. I mean, they're not commercially friendly to begin with, and they're outdated for the GDPR. But most of the time, the information that you need to fill out in the appendices or the data elements that you're transferring, they're not even filled out. It's just blank. They just append them to the end of a contract, and they're done with them. They've never read them. They have no intention of actually reading and complying with each element of it. And frankly, right now, if you did comply with each element of them, you would violate GDPR, but they've said that's fine, still use standard contractual clauses. So I'm really excited to see what the next version of the standard contractual clauses are going to have. And they've been promised, I think, by December. Is that right?
Yeah. No, they should be actually coming in the next couple of weeks. We're recording this on September 3rd. Earlier today, there was a hearing in the European Parliament, and the European Commissioner, Didier Reynders, said that they're almost ready. So let's hope that we'll see them maybe by the end of the month.
Yeah, he said that the first draft would be out by the end of this month with final release, most likely by the end of the year. But what I was really impressed to hear was that they are, as we had hoped and expected, including some new scenarios that have been missing in previous versions, such as platform-to-platform transfers. And of course, the various aspects that they need to respond to the invalidation of the privacy shield. So, the stakeholder meetings that they've had for the last year and a half, it sounds like they've taken a lot of that on board. We knew that it would take this decision before they would come out with their draft, because they had to adapt based on what the decision was with what they would come out with. People have talked about modular components, so you can kind of build aspects to it to make it more relevant to the specific situation. I think a lot of people are going to be looking for processor-to-processor type of arrangements, which was a really big one that was missing. So, I'm really looking forward to seeing what comes out. But the other thing is, the Commission also came out with some comments about how they think the best way to overcome some of these problems is not necessarily just the standard contractual clauses, but they want to utilize the OECD, because that was something that Bruno actually came out with in a recent discussion to say that, well, maybe they can leverage the OECD as a great way to emphasize oversight and a little less on the individual redress issue. But it was actually something that came out of a discussion in July, I believe, at the OECD, where the Japanese delegation had actually initiated the dialogue. But it's interesting that, the Commission is even proposing or floating the idea that the OECD might be an appropriate mechanism and body to have this oversight issue dealt with on a more multinational basis than just on a bilateral basis with the U.S. Because frankly, the Charter of Fundamental Human Rights in the EU is not going to be amended. There's court cases and referrals before the Court of Justice right now on member states that aren't upholding it. And that was one of the justifications that Bruno had mentioned was, well, there's necessity and there's proportionality principles and the member states are going to be held accountable. Well, we see that there are a number of member states that may not be upholding those data subject rights and legal redress measures the way they should. But to say that there's a difference between a member state and the US, you could argue, well, look at the example that we just mentioned of the UK when they were a member state. And there are a lot of these mechanisms for surveillance in place. And anecdotally, I've heard stories of companies prior to the GDPR that had been BCR certified, and not my company, where as part of their transparency obligations under the Working Party 256 document had been telling the authorities, lead supervisor authority, when they had received requests, and they were all coming from France and they weren't coming from the United States or other countries. So, we need to keep this in mind that it isn't just in the United States where this is happening. And I was really interested with the list of countries that you mentioned earlier, Kay, because a number of them have adequacy decisions, such as Canada, New Zealand, and Israel. And
right.
We've moved on beyond the days of the flight attendants looking over people's shoulders in first class for what's being read, and it's gone into other types of snooping today. So it's out there. Yeah, indeed.
Yeah. It is. It's very interesting. I know
it will be interesting to see what we'll see in the evaluations that the European Commission has also promised for the fall of all those adequacy decisions, and what will need to change in some of the countries, not only substantively to align their privacy laws more with GDPR and offer that essentially equivalent level of data protection, but also from the Schrems 2 and Schrems 1 perspective of government surveillance. Chris, just to be clear, the Bruno you refer to is Bruno Gencarelli, right? The head of the International Transfers Unit of the European Commission.
I should have been more clear about that, but yes, you're spot on, Paul.
Yeah. Okay, we have a couple of things we can go to, and our listeners are probably like, ooh, ask them this, ask them this.
Of course.
So I want to touch on the LGPD.
Yeah.
For your concerns on that. But I'd also like to touch on, not your concerns, but maybe your thoughts on, as a global major pharma company, anything that is specific in your field that is causing you to a little different level of work, or maybe a little different focus from what other multinational or global companies might be doing. So either one of those, or CCPA. Hey, we could talk about CPRA too. So, just draw from a hat.
I can talk about any or all of them, but let's see, which one do I want to take first? Well, let's go with Brazil, because that's been in the press a lot with the Senate changing things at the last minute to have it become effective immediately. Of course, the enforcement of it won't begin until August of next year. Now, the international transfer provisions are relatively close, but there are a number of differences. They call for, standard contractual clauses, global corporate rules, even validity seals for quality certificates and code of conduct, all in line with the GDPR. But they do also look into when it's necessary for international legal cooperation amongst law enforcement. That's basically the case for the EU as well. Necessary for the life or physical safety of a data subject. That's kind of comparable to the GDPR for processing. I wouldn't say that's necessarily a legal justification for an international transfer.
Right.
And the specific and outstanding consent for the transfer. Now, that would be comparable to an Article 46 derogation. But you've got to be really specific under Article 46 for that, where it's got to be kind of a one-off, where it's a really explicit consent by the data subject, that they fully are aware that it's going to go to a country that doesn't have adequate protection, and that they're basically waiving their rights to do anything about it and signing over their first child along with it. So in the Brazilian context, I think we're going to have to wait and see when the new data protection authority that's now been established, when they're going to come out with guidance and what they're going to say about how that type of thing is clarified. Because if you rely upon only the data subject consent, you're going to run into issues. Now, I know that's the law in Russia. You can't export anything without the consent, but as an employer, you don't have the issue in Russia like you do in Europe, where employee consent is always deemed to be under duress, and you're never really going to be able to rely upon it, and it can always be withdrawn. So you have no idea how long it's going to last. So that I think is something that's going to have to be fixed under the Brazilian Act.
And one of the things that stands out to me about that is the adequacy portion. So even, I don't recall if the Schrems 2 decision specified this or the FAQs did, but somewhere in there from a regulator or the board was the comment that individuals, when they're transferring data and it's not between two corporate entities, are deemed to have read and understood the risks that they are taking. I'm not sure that the average person, and maybe I'm wrong, y'all are in Europe, I'm not, understands when they read a privacy notice, if they read the notice and they provide information, that they understand what the adequacy means or what the risk is in transferring their data to another country. Most people I know would not understand what risk it would mean for their data to go to another country.
It would, in most cases, I don't think the individual would be sophisticated enough to understand it. Now,
even if they read it.
Especially if they read it.
Even if they read it. And most often they don't. Especially if they read it. And if they stayed awake long enough to have completed it. But, and even if you have a sophisticated set of clientele that you're interacting with, such as healthcare professionals, they have to have had extensive education. You can't guarantee that they're going to definitely understand it.
Who does?
But
they don't even understand HIPAA, let's be honest.
Yeah, they don't understand HIPAA, but who does? But I liked your question about adequacy, because, there's been a lot of complaints that there's been an insufficient number of countries that have been granted adequacy and that there should be more adequacy decisions. Well, of course, that's easy.
There's only 11 or 14? I always can't remember the numbers. Either 11 or 14.
Yeah, but you've got a number of the smaller size markets involved in countries that are dependent on EU member states or were at the time. Like Jersey, like Isle of Man, like the Faroe Islands. So that's a pretty limited bit. But importantly, Israel, Switzerland, Japan. There's some countries with some major trade with the U.S., with the EU, and New Zealand, that have those adequacy decisions. And we understand from discussions that South Korea is very close. That's going to be another big player. But
South Korea is the one country of privacy laws that I would never like to manage.
They're constantly being amended. It's very
strong.
Yeah, it's very strong. And labor unions love to use the constantly updated privacy laws as a means of applying pressure on different things to companies' management.
Yeah, frankly, South Korea's privacy law is the strongest single country privacy law in the nation to me. I mean, in the world to me.
Yeah. Well, a little tidbit of news about our binding corporate rules. When we first set it up, a lot of people think, you follow the GDPR. And in some sense, yes. But we originally based it on the South Korean and Japanese laws, because at the time, those were the two most stringent in the world. Yeah. And with time, we have continued to add to it and raise the bar of the standards that we apply to also include the GDPR. We've looked at the Brazilian Act, the regulations out of Israel actually add a lot. And we've looked closely at those and I'm taking a few of those things on board as well. So as each of these countries take the GDPR standard or something equivalent and add a twist to it, we look at, what is that little twist? And is that something that we want to incorporate into our rules? And I always revert back the old kind of compliance mantra. Mm-hmm. We always apply the higher of either our corporate standard or the local law. So we've avoided talking outside of the EU within the company about our global privacy program as being GDPR. We always say it is our corporate policy. And that's how we communicate it to the employees outside of the EU, because they could care less about the GDPR.
Right.
But corporate policy 13.2, which is our corporate policy for the global privacy program, is in fact binding on everybody in the company. And that's what we revert back to. And when it's framed that way, that's much easier for employees to acknowledge and to say fine and comply with.
Consistency breeds compliance.
Yep.
So you have very clear binding corporate rules. You also have the APEC cross-border privacy rules. How did you manage that process to get them aligned, to get them approved also in alignment? Does that process work at all? I know from my DPA days that we were discussing referential documents all the time between BCRs and CBPRs and ensuring that there could be interoperability, which was something that especially the French really wanted. But you are one of the few that have actually done it. Does it work?
Well, it does. And we actually did it backwards. Because most people would think that you would obtain your binding corporate rules first, and then the CBPRs would be just an easy extension. We actually did the CBPRs first. And then
which is easier.
And this was all done by Hillary. And then,
and let me clarify. When I say easier, I don't mean that implementing the controls or the standards or what you have to abide by is easier, but obtaining CBPR approval is an easier process than BCRs. I actually, and I'm going to brag on this, was with the first company, and I was the privacy counsel that filed the first dual application for BCR processors and controllers. So I understand the process completely, and getting the CBPRs is an easier process through the regulators than BCRs is.
Indeed. And our BCR application was quite unique because we basically took the CBPR policies and framework and expanded upon that to show what else we had built into our program to meet the binding corporate rules provisions, which at the time was under the directive. Yeah.
I love what y'all did. I love it.
And it took some discussions, but we got it approved. And we're actually in the process of updating our binding corporate rules now to make them fully GDPR compliant and to show to our lead regulator. We're actually changing our lead regulator, not because we used the UK in the past, which we did not. We had the Belgians as our lead regulators, but we're actually shifting to the CNIL, and the process is going well.
The process is going well. That's all we need to know. But it is interesting because not many companies have followed your example, either to do it in the order you did it or to do it the other way around. Why would that be? Why are these intra-company privacy programs, compliance programs, not yet massively popular? Because in my view, once you have done the legal work, it is a massive advantage as well to show to the world, hey, listen, we really care about your privacy, full stop, no commas and no maybes. This is all that we do.
Yeah. Well, there's two things out of that, Paul, and I completely agree with you. First, it facilitates the international transfer of the data, and it reflects the fact to the local data protection authorities that you recognize the rules that they have, the possibilities that they have, and you utilize it. Just to say, I have an EU binding corporate rule, well, some are kind of quasi-recognizing it. Australia and New Zealand come to mind under the new Kiwi Act. But, you want to talk to the Data Protection Commissioner, and Philippines, who's really raising the bar and adhering now to the APEC binding corporate CBPRs. But, for somebody in South Korea or Singapore or Japan to say, well, we have the CBPRs and we're utilizing it, that goes a long way in your discussions with them. It also shows a commitment to being compliant with various privacy frameworks, data protection frameworks, whether it's the Privacy Shield, which you still are bound to if you have certified, unless you have withdrawn that certification with the Department of Commerce. But it shows that you are meeting certain standards and you're holding yourself out publicly to it. Now, the two that I just mentioned, we have trust agents to help us with that certification, and TrustArc is our agent for that. And we rely upon the good work in that annual review for saying, this might be some recommended language to add to your policies, or the site may have an improper logo on it or whatever, and that's important for us. But being able to look regulators with a straight face to say, we are holding ourselves out to the gold standards, and it's these three different sets of rules that you have just mentioned, and locally that will follow the specific rules of data localization in Russia, or all 13, I think, the regulations in Israel, or whatever. It helps, and it's a good PR thing to say that we're not just kind of barely scraping by with the minimum and just kind of ticking the boxes, but we're proactively going out there. And when we find legitimate, reputable frameworks from which we can display our adherence, that's a competitive advantage for us. And it makes it easier to continue to circulate transfer data around the world, because we will then take advantage of the systems in Argentina or in Serbia or Switzerland or wherever for recognition of our binding corporate rules, either the European one or adapt that application to meet the standards for that country. So it goes a long way to be able to walk into a regulator and say, I want to utilize your system, multilateral or domestic, for the transfer, because we respect your rules and the importance of protecting the data protection of your citizens.
Let's talk just a little bit about CCPA, and specifically looking for the CPRA. So your thoughts on, and I don't want to put you in a difficult political position at all, but what are your thoughts on the fact that this would be a referendum, and so it could never be changed by legislation if it's adopted? So there would be no more CCPA amendments.
Well,
to my understanding, and maybe I'm wrong. I don't think I'm wrong, but maybe I am.
I seriously doubt it. My understanding is Article 25 of the CPRA states that once it becomes law, the California legislature will only be able to amend it to increase the privacy protections to the California residents. In no way will they be able to claw back. That's a unique feature. Now, latest news I have seen, which was from the end of July, was a poll showing 80%
24.
of the respondents in favor of voting for the proposition. 424. Yeah. And I'm not surprised by that. I would not be surprised if it is in fact passed. Now, this is just a repeat of what McTaggart did last time with the CCPA, but in that case, the California legislature agreed to actually adopt legislation to avoid the referendum. With COVID,
and we're way past the date for them to do that.
Past that. Yeah, that's not going to happen. And they basically abdicated it to the referendum in November, and in all likelihood is going to go through. Now, in light of, McTaggart was very clear that he wanted to get a state adequacy decision from the EU, which at the time that the number, the collection of the signatures for the referendum came through, sounded plausible. In light of the Schrems II decision, no matter what the local law in California reads, the fact of those two federal aspects of FIS 702 and Executive Order 1233, that will just basically kill any discussions of an adequacy decision. What will happen, though, is if the CPRA is passed and the Senate flips to the Democrats and Biden is elected as president, that changes the dynamics in Washington, D.C. With
just a little,
with more than likely the CPRA acting as the benchmark against which federal legislation would come in.
Right. And that is a big possibility if the leadership changes. And all of this is pending on leadership because Kamala has been a privacy hero of mine for a long time.
Yeah.
And so we all know that she has a big interest in that. So it's going to be exciting to see what happens if the leadership changes.
It's a big if.
We'll it's a big if. I don't think it's going to be as exciting if the leadership doesn't change, although it will be just as emotional, perhaps in other ways, maybe exciting in other ways, but not on the privacy front. But looking at that, so taking into account your opinions in Europe and from California, the input there, you're an American living in Europe. What's the perspective like? Boots on the ground there, watching everything happen from Europe, in Europe, and looking towards the United States. Any thoughts there?
Well, just to be clear, I was raised in America, but I am both Belgian and American, and I've lived in Europe significantly longer than I've lived in the United States. And I've been gone for 25 years this go around. So the news that I get is basically the exact same news that everyone else in Belgium or those with access to international press obtains. I have to say, I'm very tired, even with what we're getting here, of the continuous election cycle in the news before every one of the primaries. And it's just like how people can live with it day in, day out in America. I don't understand.
Just to be honest, it's exhausting.
It is. So my introduction to data protection has only been through the European lens, whether it was the directive or the regulation. And I understand and comprehend the omnibus aspect of it. To only have HIPAA and the Fair Trade Protection Act, et cetera, in a very limited manner for the US or state data breach rules, that's a pretty narrow scope, or common law privacy of tort type things. It's a much more narrow focus. Some of my family still lives in the U.S. and the hand over your data for your Fidelity card at a grocery store. Nobody thinks anything about it. Oh, I get the coupons. I get a discount.
Right.
And it's like, well, you're monetizing your personal data through providing it in exchange for coupons or a discount. And they don't quite understand that. So there is a perception. And I think there's going to be a great deal of education and information exchange required to make people aware of what these rights are from a European perspective. It's going to take time. The CCPA has started out with the easy part about, well, here are data subject rights that you can exercise for what information do you have and don't sell my data. It's not an omnibus data protection piece of legislation. The CPRA moves more close to it, but it isn't. Mm-hmm. If you do a side-by-side comparison, it still doesn't get you all the way to a GDPR. Right. In terms of what companies need to do to prepare for it, the bulk of the work took place in the CCPA. The CPRA adds things behind it where if you have a general policy that applies in countries beyond the US, you're probably going to be meeting those additional standards anyway.
Right.
But setting
and
up...
a lot of people, to be frank, a lot of people don't understand that the CPRA is not a completely new piece of privacy law for California. It amends the current CCPA, and a lot of people don't realize that. So it does amend the current CCPA, and the overwhelming majority of the CCPA stays in place, but it's still, as you say, not an omnibus law. It's a little closer, but it still doesn't quite get there.
And, things like the exemptions for medical information under the California Medical Information Act goes much wider than what you have under the HIPAA exception for clinical trial data, although that text has now just been amended by the recent, AB 1271, I think.
Yeah, I think so.
Yeah, they're trying to make some clarifications on it because it was a very narrow definition for the HIPAA specific clinical trial
data. And when you try
to
narrow and eliminate connotations, and it's really hard to do that. We know
it is. But to expand it to the more things, and then the derogation on the employee or employer-employee information. That's two major chunks that fall out of it. Now, we have substantial operations within California, so
just a few.
And I had to explain on several occasions to people, well, Chris Foreman, employee in Merck in California, we don't have to do anything with respect to that relationship. But if they were a consumer for anything else, they would have the right to make the request for information beyond their employment information.
Right.
Oh.
But even the employment exception, the moratorium on the B2B and the employment exception isn't in totality.
It's only been postponed by a year unless the CPRA has been approved.
That is true, that just passed in the past couple of days, which was fantastic. But even then, it's not a complete exemption from CCPA. There are still certain elements that fall in place, most especially the fact that they can still sue for a breach in both situations.
Indeed.
But for employees, I think the other biggest part that stays in place is the notice. And a lot of companies do not provide notice to their employees. And if they provide them to their employees, they're not providing them to the applicants.
Yeah.
So they're like, oh, well, our notice online covers the applicant notice. It's like, really? You put what you do with applicant information in your online privacy notice.
Yeah.
Most companies don't. Let's just be honest. We just kind of take employees for granted, and they have to work. It's always under duress if they consent anyway, so who cares?
Well, we have our existing global privacy program today, and that covers all stakeholders, employees, vendors, suppliers, HCPs, healthcare professionals, patients, etc. But we're actually creating a standalone workplace privacy program specific to job applicants, to your point, current employees, former employees, consultants.
Sounds good.
And visitors to our sites.
Nice.
And we thought there's such specific aspects and concerns that group has beyond the other stakeholders that it justified their own standalone.
I think so.
It's about to come out. We're still working on it. And of course, we have to take into account local laws and work council.
Welcome to Germany.
Agreements in other countries. So a little.
Love work councils. Love them.
They have some positives.
They do.
We set it up the same way as our current program, where we have our general rules, and then to allow flexibility where local law or works council agreement contradicts or exceeds the standards that we have an exception section at the end of our standard, our specification for what the privacy program is, where we call out the unique aspect in that country.
Nice.
So that way we don't always have to go back and always change the underlying rule book, but we only have to build in the exceptions. Right. And we tag that so that when we do our privacy impact assessments, we can immediately pull up what those exceptions are for that specific country and reiterate in the guidance to the business owner that they have to take into account, well, since this will also take place in country X, you'll have to remember this specific aspect too. It's a huge undertaking to create that type of a document with not only your standard rules, but all those exceptions and keep it up to date. But that's one of my main responsibilities, is ensuring that we do so. So I read lots of different materials coming through NIMIDY and other sources on a daily basis.
Love that NIMIDY research.
They do a pretty good job.
They do a pretty good job.
Especially with the new oversight, right?
Chris, before we wrap up, there is one more thing I would like to address with you, because we cannot speak to one of the leading pharmaceutical companies in the world currently working on finding that solution to us working all at home, vaccines and treatments for COVID, without discussing it. I'm sure that Merck is indeed working on these issues, but to what extent is the Privacy Office involved at all?
Well, terribly so. I've been involved in so many different things, and I actually am the dedicated contact person within our privacy office supporting our Merck research laboratory. So I'm the contact person. And that's because when I was legal in-house counsel for Merck, I supported our regulatory affairs Europe group and pharmacovigilance. So I understand the medicines legislation in the EU. So I kind of bridged the two. Doing due diligence on acquisitions, because we've bought a number of companies to bring in compounds for either vaccines for COVID-19 or for treatments of those that already have it. So that's one thing. Remote monitoring of clinical studies. Not only because we have an obligation to monitor the study results and to work out under the FDA rules or the EMA rules how you actually protect the personal information when you transfer or somehow have that see a clinical research manager or monitor or associate actually view the documents, what may or may not have been redacted, how secure is it in its transfer. Then you get into the issues about, well, what about working with the investigators that want to have remote interactions with the patients in the study? That's very different because now you're going beyond a legal obligation and you have to get into providing the appropriate consent to the patient that they understand not only are they in the study, the data is being handled, but that it's going to be done in a slightly different way. And what the potential...
A new slightly raised element to telemedicine.
It is. So we've had that. Issues about taking temperature testing or employee safety for visiting the office or being in the office, requests by governments or landlords for certain information about the patients before they would open up the building again. So there's a wide variety of topics that come out and you have to think about all of these. These aren't all the types of things that you're taught to be prepared for at law school.
Right.
And
no, not quite. I mean, even I'm teaching privacy law in our law school. And I'm going to have to change the syllabus this next year because we have massive new topics to cover.
Yeah. And just like the bit about asking questions about visitors to your own sites, we were asking everyone to do that. And then rightfully, there were some of the delivery services that said, well, wait a minute, you're asking for more information than you need, and we already cover it. So we ended up having to negotiate, and I think it was an excellent solution, agreements with the different delivery services for what they do to ensure on a daily basis that their drivers they've been checked on a daily basis and they meet certain standards. And on that basis, we felt comfortable that they could enter the building. Whereas anybody that just comes in from any other type of company, we would be wanting to ask them the minimal information to ensure where they've been or if they feel that they've been sick or things like that before we grant them access to the building. But you have to weigh all of these benefits of what do you need to cover the circumstances and what's the minimal amount and no more. And we actually had to work with a variety of the site management parts of the company and elsewhere to make sure that what they asked for in the form was not going too far and pull back on it. But then we also had, what about contact tracing and how do we do that? We have our own global health safety group and working with manufacturing sites and others, what the rules were locally for how we could do that. The rules for that type of employee safety under OSHA in the US are vastly different from, say, the Netherlands. So, guidance had to be provided. You can collect what is allowed locally, but not more. And if we have to report things to the United States, because, the global senior executive crisis team wanted certain data, we had to provide certain bits to doctors that we have within the company that were charged with doing that type of work for global employee safety, but that's a very limited group of maybe 8 or 10, and then only anonymized information and aggregated data could in fact be passed to headquarters for purposes of what this senior executive crisis management team needed. So we had to walk through what the needs were of the different stakeholders and ensure that they got what they needed, but in a compliant way, and that we minimized the data that was being exchanged with each step to ensure that the privacy of the individuals were being protected.
Lots of lessons learned today, Chris. Thank you so much. That concludes another episode of Serious Privacy. If you like our series, please subscribe in your favorite podcast application and do tell your friends and colleagues about us. Should you have any questions or suggestions, or if you would like to come on the show, please reach out to us via seriousprivacy@trustarc.com or via Twitter at podcastprivacy. You will find Kay on Twitter as Heart of Privacy and myself as your Paul B, and you'll find us on Instagram as Serious Privacy Podcast. Thank you again for listening to Serious Privacy, and until our next episode, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, that's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.